Uh, Sakshi Vadva. Sakshi, we are going to start now. Okay, is
Atreyee. Oh, great.
She's here. Okay. Okay. I will now request Sakshi Vadva to take over. Okay, Sakshi.
Good evening, everyone. I'm Sakshi Vadva from the editorial team of TheDaak. With greater delight, I welcome you all to the 5th session of TheDaak Baithak, a forum of digital conversations that delve into a variety of academic themes. The Baithak is a humble attempt to build a community of young scholars, budding thinkers, readers, and writers who wish to critically engage with socio-political and cultural subject matters, thereby opening horizons for new ideas and enriching conversations. Today's discussion is titled as Selective Justice, Interpreting Gender Neutrality in the POSH Act Through Feminist and Queer Lenses. Since the passage of the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013, there have been several judicial deliberations on whether this law can be broadly interpreted to be gender neutral or not. This talk will look at two seemingly opposing recent judicial decisions on this issue and attempts to contextualize them within the larger feminist discourse on gender neutrality and laws against sexual violence in India. The purpose of this contextualization is to illustrate how the judiciary's reasoning in its decisions on the issue of gender neutrality in the POSH Act selectively draws on feminist and queer arguments supporting just laws. Today, we are very pleased to have with us Atreyee Sengupta, who is a doctoral candidate at the School of Law, SOAS. She has also joined as the Indian Law Review assistant editor. Her thesis intends to rethink feminist engagements with anti-sexual harassment laws and institutional mechanisms in Indian universities, interrogating the relationship between law, justice, and everyday feminist social resistances in these university spaces. We also have with us today our discussion, Sakshi, who is also a doctoral candidate at the Department of Law, SOAS, and is a recipient of the prestigious Ubel DTP scholarship. She is currently working on a thesis titled An Ethnographic Study of Emotions in the Family Courtroom, a case study of Punjab and Haryana. Her doctoral research is trying to shed light on how political emotions are employed as tools to discipline female litigants within the folds of acceptable femininity with family courtrooms in India, thereby exploring the intersection of law, political philosophy, and gender. We now open the forum for further discussion.
Thank you, Sakshi.
Okay, I will now request Atreyee to come in. We ideally have 35 minutes for you, but I'm sure that we'll be willing to listen to you more if you need more time. And after that, we'll open the session for Sakshi Sharda. We have two Sakshis actually in the team and in the call right now. So then we'll go to Sakshi Sharda for her comments, and then we'll open the forum for questions from the participants. So welcome, Atreyee. Thank you so much for agreeing to do this. And to you now.
Thank you so much, Jigyasa and Sakshi, both of you. Just a disclaimer that there might be a little bit of background noise because it's summer, so I'm not able to close the window and there's a lot of sound outside. So there might be a little bit of disturbance. But to come back to the topic of the talk, thank you so much for inviting me. I'm glad to be here. Thank you, Sakshi, for introducing the topic for today. But what I would like to do is go a little bit beyond the article in EPW, because I'm also thinking through certain themes, certain conceptual categories as the time goes by, and my PhD work is also progressing side by side. So there are certain thoughts that I have in my mind and I would like to share with you guys here. And I would welcome any suggestion, any inputs that what you think of those categories. So I would not actually take about 30 minutes. I would take lesser than that because I want the discussion to be like more fruitful than the presentation as such. So what I would like to start with is kind of think through this article, but also trying to think through some thematic and conceptual issues. So in that article, I talk about how gender neutrality is interpreted in these two decisions of Malavika Bhattacharya versus the High Court of Calcutta, and the other article and the other judgment against the appeal of Binu Tamta. But what I want to talk about here is a little bit about how this judicial interpretation of gender neutrality of the accused category and the category of the aggrieved actually also tells us a little bit about how the court looks at this category of injustice of sexual harassment itself. So how are they creating this category of injustice? How are they looking at sexual harassment as an injustice as such? And to begin looking at that particular thing, what comes to our mind is one of the things that is there in the article as well, which is the method of contextualization. So that contextualization is a very feminist method, right? So, and I'm very interested in kind of historically mapping feminist discourses around issues like sexual harassment or sexual violence, because it tells us a lot about methodology, both in terms of feminist resistances and feminist engagement with law. And what feminist standpoint theory tells us is that whatever situated knowledge that we have, one, that it must be deeply contextualized, and that despite that contextualization, there is only a partial or limited understanding of that viewpoint. There can never be a complete understanding or a complete knowledge system that can be created based on any situated knowledge. And this is basically the opposite of how we look at law, because law essentially is this objective, rational tool that just attends to the immediate problem at hand, does not necessarily become interested in the context as such, because it is recommended rather that judges adhere to this objective point of view. And feminist legal theorists have, for the longest time, pointed out how this understanding of objectivity is deeply masculine. Catherine McKinnon comes to our mind very easily when we think about how objective standards of law are inherently the perspective of the masculine standards of law. But as we at SOAS do a lot of this colonial understanding of law, we also understand how not only are those masculine point of views of what objectivity is and what law is, but also it's deeply colonial. So whatever understanding of law we have today is a result of colonialism. We do not have any understanding of law which goes beyond colonialism as such. So if we look at the laws on sexual harassment, for instance, in India, even before in 1997, the Vishaka guidelines came into being, which looked at sexual harassment of women at workplace, what laws on sexual harassment we had were criminal provisions. So Section 294, Section 354, and Section 509 of the Indian Penal Code 1860 are the provisions that we had regarding sexual harassment. And interestingly, of course, none of these laws actually use the term sexual harassment. Those were only concerned with, 294 was concerned with obscene acts in public. So 294 actually was a gender neutral act. Anybody who resorts to obscene songs, obscene words in public would be convicted under that act. But Article 354 and Article 50, Section 354 and Section 509 were actually gender-specific provisions which related to outraging modesty of a woman. So 354 was with use of criminal force, outraging of modesty, and 509 was use of words or gestures to outrage the modesty of a woman. So this idea of modesty being outraged comes directly from this colonial Victorian understanding of sexuality. So these laws were not actually there to protect women from sexual violence, but those were to control the sexuality of women in public. And as the history of India goes, that this idea of modesty itself is very much intrinsically linked with caste. Who are the women who are actually stepping out of their house in the public? So at the time when these laws come, of course, there is this big divide between public, private, and upper caste women are not generally venturing outside of their homes. But those are Dalit women who are stepping outside for work. And this idea of modesty then creates this conundrum of, if you are to prove that a modesty has been outraged, you have to prove that the woman has modesty in the first place. And who has modesty? Do women who are directly venturing outside for work, are they the ones who have modesty, or are the ones whose sexuality is being protected inside the home? Are they the ones whose modesty must be protected? So that kind of a divide is very much built into the legal system from the very beginning. And surprisingly or unsurprisingly, those laws have not really changed. These provisions are still there in the IPC and continue to operate. The one which has been added into the criminal offenses according to around sexual harassment is Article 354, Section 354A, which has been added after the 2013 Criminal Law Amendment Act. Again, that particular understanding of sexual harassment, so the vocabulary of sexual harassment then enters into criminal provisions through this 2013 amendment. But what ends up happening is that unlike the POSH Act, which talks about the unwelcomeness of certain acts and has certain understanding of consent, we can of course debate about how flawed that is. But in 354A, there is actually no conversation about consent at all. So as Prabha Kotiswaran points out, 354A can also be used to criminalize consensual sexual banter. It's not just that there is only when there is a contravention of consent that 354A can be used, but it can be used even if two people are consensually having a sexual banter and it actually goes against the public morality. So these are the criminal provisions that we have, and we can understand how these criminal provisions are very, very gendered in the sense that only women can use these provisions and only against a man can those be used. So both categories of the aggrieved and category of the accused are very much fixed. When Vishaka comes in 1997, it does move away from this modesty related provisions. And it talks about unwelcomeness of sexual acts, constituting a sexual harassment, quid pro quo of sexual harassment at workplace, and hostile work environment. And so does the POSH Act, takes up all of these things and becomes a legislative act as such. Vishaka is only a guidelines, and the main problem with Vishaka was that people were not abiding by those because those were merely guidelines and not like legal provisions. But both Vishaka and POSH remain very much gendered in the sense that other than women, nobody can make use of those acts, and it can be only used against a man. Now, one of the biggest debates within feminists in India has been that whether or not provisions around sexual violence of any kind should be made gender neutral or not. And this is one debate that became very, very prominent during the 2013 Criminal Law Amendment Act and the constitution of the Justice Verma Committee, where feminists and Justice Verma Committee finally actually talked about how it's very important to make the category of the aggrieved gender neutral, because power structures operate in such a way that not only women, but other marginalized genders and sexualities also are at the helm of receiving end of sexual harassment at workplaces. And also to not make the category of the accused gender neutral, because even Jagori's submission actually points out how majority of the cases of sexual violence are actually of men committing sexual violence against women, children, other gender minorities, other sexual minorities. So that makes it very counterintuitive if we also make the category of the accused gender neutral, where the power dynamics is so very skewed in case of workplaces and in public places as well, that it's almost impossible to maintain a parity in terms of gender neutrality of the both categories. And the other very important aspect which often gets overlooked is that in the POSH Act, there is actually a clause on false complaints. So in any case, there is this provision that can be again and again used against women as countersuits to say that whenever they bring complaints, that it's a false complaint. And as Sakshi was, I think, talking about fake cases yesterday in terms of domestic violence and dowry complaints, here again, the question becomes, what is this category of false complaint? So how do you prove that something is a false complaint when the believability of the complainant itself is very much skewed from the very beginning? Nobody wants to believe that sexual harassment has actually occurred in a workplace. So proving sexual harassment itself is such a big problem. And on top of that, you add a clause on false complaints. So how does one even get to the point of proving that one has faced sexual harassment? And imagine in this case, if the provision is gender neutral in terms of the accused, what happens to the marginalized genders and sexualities? How are they supposed to bring any complaints when there is absolutely no support system within institutional spaces to enable them to come up with these complaints? Now, to go back to the judicial reasoning of being completely opposite of the feminist method of standpoint, which takes situated points of view, the law, of course, takes the life of its own within the courtroom, irrespective of what the words of the law are. And that is something that has been pointed out by Pratiksha Bakshi, Mayur Suresh, that it takes a life of its own. Thus, whether or not the aggrieved or the accused can be gender neutral or not depends on the courtroom's immediate logic rather than the word of the law as such. And now I'm actually coming to the point where I'm trying to think through certain categories where this partial reading of the context becomes very prevalent in judicial reasoning. That unlike the feminist method of mapping issues contextually and then framing it as partial and situated knowledge, the courts do exactly the opposite of this. They take the partial context and frame it as the objective truth, creating a displacement of the subject and the very injustice of sexual harassment. And here, I think the question becomes whether the law or the spoken law is at all interested in justice when it is least interested in this category of injustice. And here by injustice, I'm again referring to the understanding of injustice as a subjective experience of being wronged that Judith Scalar points out in her work. And it's also important to recognize that this subjective feeling, even when we are talking about this as a subjective experience or subjective feeling, it's not actually an individualizable feeling as such. It is also very much related to the structural injustice that is built into the system of these workplaces that makes someone vulnerable to instances of sexual harassment. So when the Malavika Bhattacharya judgment says that the perpetrator can be anyone, it uses the logic that if same-sex marriage can be socio-legally debated, same-sex harassment can also be a reality. What does that tell us about how the court is looking at the injustice of sexual harassment? Certainly, it's not looking at sexual harassment as a structural injustice, because it's very logic of saying that just because there is a debate ongoing about legal marriage, legal same-sex marriage, that sexual harassment can be a reality is absolutely a flawed kind of reasoning, where it does not recognize sexual harassment as a structural injustice and an abuse of systemic power. And most importantly, in this entire deliberation that goes on through this judgment, there is no reference to LGBTQIA persons at all or their rights to bring a complaint. It is entirely satisfied with contesting that the category of the accused should be gender neutral and can be interpreted as gender neutral, rather than looking at who are the people who can then bring complaints. And it is very much concerned also with the gender binary. It becomes an individualizable problem, which is faced either by a man or a woman. It has no kind of understanding of what could be the repercussion of structural injustice of being subjected to sexual harassment on marginalized genders and sexualities. In contrast, the other judgment, which is the Binu Tamta petition, the question about gender neutrality of the aggrieved person category is met with a resounding no. So in this particular case, the court actually recognizes that making the sexual harassment law fully gender neutral would actually be dangerous. But it also refuses to recognize the debates that were going on in 2013 regarding the category of the aggrieved. So it, on one hand, says that if you make the category of the accused gender neutral, it would not be recognizing the power inequality that is there in the workplace. But at the same time, it also fails to totally recognize the nature of structural injustice, because it says that the category of the aggrieved also, we cannot make it gender neutral because it is particularly targeted towards women. And thus, it also does a partial reading of the feminist and queer debates that were going on at that time. It reads this problem of sexual harassment as a gendered problem, but as a very simplistic binary term. It avoids intersectional or more complex structural issues at play that make someone vulnerable to sexual harassment in the workplace. And that is why I think it's very important for us to constantly interrogate not only whether law can give us justice, in this case, whether courts can actually give us justice, but also about whether or not they're actually interested in giving us justice at all, or whether they are only limited to kind of looking at the boundary between legality and illegality, which is something that again takes back to the criminal justice drift, right? Because in the case of the criminal law, we know very well that the question is actually on public morality, illegality, legality, and not necessarily about justice at all. There is no question of justice in the criminal law when it comes to sexual harassment. And here again, when we look at the way in which the Sexual Harassment at Workplace Act under POSH is actually adjudicated, it reflects that kind of a criminal justice drift, where the kind of reasoning that one uses to apply criminal law again becomes visible in these civil law jurisdictions as well, where the question becomes whether you are actually contravening certain legal provisions and stepping into a domain of illegality, rather than looking at whether you're facing injustice and whether you are someone who is seeking justice through the law, whether the law can at all give you justice, because the law is certainly not interested in looking at the category of injustice at all. So this is where I am thinking through these terms. I think I would be happy to kind of go into a discussion now and engage with all of you.
Thank you.
Thank you so much. I would now invite Sakshi Sharda, who's the discussant today, to come up with her reflections on the piece that was shared and on the presentation. If you have any questions, Sakshi. Okay.
Yeah. You. Atreyee, I feel like I've heard this before and from you particularly because these are conversations that we've done, right, in personal settings. But what I find really intriguing to the conversation that you brought today is the category of injustice, right? You alluded to this idea that the state finds it so difficult to recognize gendered violence as an injustice in itself. And it becomes even more difficult for the state to recognize it within the structures of law and legality. And then I feel like law gives them the ambiguity of the term accused, the ambiguity of the term aggressor in itself gives them the space to steer clear of that structure in itself, like to steer clear from that injustice. So I was wondering if you'd want to allude a little to in the conversation about why this inherent ambiguity exists. Now, there's a second thing that I was thinking through, and I think I was thinking through this piece because marriage is getting a very interesting space in the conversation around sexual harassment, right? And especially the conversation around same-sex marriage is getting a very interesting place in sexual harassment. And it's bringing me back to Madhavi Menon's work, who's very explicitly said that, if you think about marriage and same-sex marriage is a very important category to recognize citizenship, it fails the entire movement in itself. But then it also brings me back to the question that if POSH legislations cannot come to a space where they start recognizing that the category of the accused can be somebody can be the category of the aggrieved, can be somebody who needs to be gender neutral at this time. So if we're not coming to that space, it's also coming from a particular restrictive understanding of who is modest enough, which is what you were alluding to at the beginning of the conversation. And that was bringing me to a space where how we began this conversation became interesting, which is coloniality, right? Coloniality within itself brought certain ambiguity to law. It created a certain structure to law that we now don't want to recognize. But the problem is that it's not that India hasn't tried, right? When it has tried to make space for the embodied existence of the subject, right? And that embodied existence of the subject, it failed. Like marriage laws has its own problems, but it did try to create an embodied existence of the subject, especially in the context of marriage, right? So then how do we then read the entire structure of coloniality in that space? And what happens to the structure of, feminist reading of embodiment within creating law in itself? Because there is a pragmatic limitation to embodiment too when you think about it. If you think about the entire system of legal structures that exist, and it's not me saying that legal structures don't need to be challenged, yes they do, but what happens to the conversation on sexual harassment? What happens to the category of the embodied subject? What happens to our reading of coloniality if we think about the larger system that is in place? I have a third question, and I think I'm going to stop at the third question, and then we can, maybe wait for the discussions and wherever people take the conversation further. My third question is to look at the very two laws in the paper, sorry, the two judgments in the paper, and I find it very intriguing that the state found it very easy to read gender neutrality into the category of the accused, but extremely difficult to read the same gender neutrality into the category of the aggrieved. And I was wondering if you'd want to talk a little about that.
Thank you.
Thank you, Sakshi.
Yeah, thank you, Sakshi. And I think we'll have Atreyee, how would we want to do this? I think you respond, because these are a number of questions. So let's have you respond to this first, and then we'll open up the session for questions. Meanwhile, if you've within the participants, if anybody wants to type their message out or type the question out, they can do that. But you are allowed to kind of unmute yourselves after Atreyee has responded to and ask your questions as well. To you, Atreyee, now.
Thank you, Sakshi, for the questions. They're great questions and long questions. So if I forget something, please remind me. So yeah, about the ambiguity within law. So I think law specifically works with ambiguities, right? Because it's actually a little bit contradictory in the sense that law is supposed to be this objective, rational endeavor where there are answers, direct answers that you get, that yes, this is right and yes, this is wrong, which is a very positivist understanding of the law itself. But inherently, as we see more and more that law, as it takes its own shape and form in courtrooms, it then operates within certain areas of ambiguities very well. And I think, as you pointed out, in the cases of marriage, this becomes very prominent. And one of the things that when I have been reading, I've been coming across is it also becomes very prominent in case of promise to marry cases, where, for instance, Arushi Garg's work actually points out that on one hand, the courtroom is telling the complainant that you actually consented, there was no sexual violence, you actually consented to the sexual relations because you were in love with the accused. But at the same time, they're also telling the complainant that how could you even believe that there can be a promise of marriage when it's not an endogamous relationship. So you see how the law is constructing a juridical category of love to say that, yes, there was consent, but at the same time saying that because marriage can only be endogamous, how can you expect that there is a promise of marriage? So law essentially then works through these ambiguities, because I think there is now, despite this kind of treatment of law, why do people still go to law? So that would be the question, right? Why would we keep going back to the law? I think it's because there is a very strong sense of legal consciousness in India. And that probably comes from a certain sense of faith in democratic institutions and democratic constitutionalism as such, because there is this feeling that despite everything failing, law actually, even if it cannot give you this immediate sense of justice or relief, it can in the long term translate into certain changes in how social legal meanings of certain understanding of sexual violence, of marriage are constructed. So I would also read this kind of, when we look at how same-sex marriage petitions were going on, it's not just about the fact that people want their immediate rights to be recognized, but it's also about the sanctity that then comes to these relationships, the recognition, social recognition that comes. It's almost assumed that if the law changes, there would be certain social changes that would automatically be there along with the changes in the law. And that is why I think, despite the fact that law operates within these very ambiguous categories of, also you can see how there is no actually precedent that is being sustained. So one judgment would say that yes, it can be gender neutral, one judgment would say it cannot be gender neutral. So it's not like there is a legal precedent that is being established over time regarding these laws, but it entirely then we have to rely on the judicial reasoning of that particular court. That creates even more ambiguity in terms of whether or not we can trust the law as an avenue for justice. But then again, that faith of legal consciousness comes into being, where when we run out of all options, we again go back to the law, because we have this very basic fundamental faith in the law as an instrument of social change, if not anything else. And yeah, of course, marriage laws are again very much constructed under this colonial regime of who is a modest woman and how do we acquire modesty. We can only acquire modesty when we are in this very heterosexual marital relationship. And as we all know that India does not recognize marital rape as a form of sexual violence, as a form of rape. So we can understand that there is, so again, going back to this idea of laws against sexual violence being there to control sexuality rather than protecting women, it actually then tells us that it's not even that the court or the law believes that women's sexuality. So the court then tells us that the modesty can only be outraged in public. So there is no recognition of sexual harassment and violence within the ages of the home. It can only be outraged when you're stepping outside and not inside your home. Again, telling us that it's really not about justice, but it's actually about illegality and legality of certain acts that are recognized by the law. So the law recognizes marriage as a legal institution. Therefore, whatever goes on inside the marital relationship is not the concern of the law as such. But what is of concern is when this kind of heterosexual endogamy is being challenged and there is a certain threat that comes up in the public, in the workplace. There it becomes important to recognize sexual harassment and sexual violence. But again, not dependent upon the subject's position, but totally dependent upon how the power dynamics are structured within that particular case. And yes, feminists have, of course, tried over time to push for legal reforms, to push for an recognition of an embodied subject within the law. But again, I think the problem is that we, because of our legal consciousness, because of this trust in law as an instrument of social change, we also expect things from law that we can't get. The law is not structured to give you the space for an embodied experience. It is very much concerned with binary of all legal categories. So either you're a good woman or you're a bad woman. Either you're a bad woman or you're a mad woman. There is no in between that you can negotiate your subjectivity within these legal provisions at all. Therefore, I think, even though, of course, it's very important for feminists to keep on engaging with the law, because people constantly go to the law and how far we can actually prevent the ill effects of law when we are engaging with the law. But despite that, I think there is this sense that law cannot really give us all that we ask from it. There are certain things that we have to get by social movements, by social resistances outside of the law, rather than completely being reliant on law for an instrument of social change. Yeah, could I answer all of your questions, or are there things that you would like to reiterate?
No, Atreyee, it's fine. I think we'll open it for discussion and I can step in again when needed. Okay. One thing, you will have to talk about the category of injustice and the recognition of the category of injustice a little in depth. You can take that as with the discussant questions that come from the audience. Yeah.
Okay. Okay. Thank you so much. And now, are there any questions from the audience, from the participants? Usually we have a whole lot of questions. Maybe I think okay, maybe people are making up their minds about the questions, or maybe Sakshi kind of did the job for everybody.
No, not really. That scares me.
All right. Sometimes what happens is that the argument is so well done that it's difficult to kind of plug holes or even come back with questions about.
Can I ask one question?
Yes,
I have one.
Sengupta.
Yes. Hi, Atreyee. Thank you for this. Was such a good, I think, talk, and I like the whole discussion was so energetic and all. I think everybody is waiting to think what questions to be posed. Sakshi has asked quite detailed question. Thank you, Sakshi, for the discussion. I have a little different question for that matter. I will not look at the POSH guideline for that matter only. Uh, just a little background, because the whole binary system and how the legal system has been made, this is something that is replicated even at the international law level also. This is something we are not so the reason I'm saying, because my work is on also male victims of sexual violence and conflict. So I was looking at the humanitarian laws and UN and everything. So the whole binary thing that you are talking about, and how the gender binary that is replicated, and even the whole Geneva Convention as such has been made, that Article 27 is based on modesty of female women and how it has been made. So how as a researcher or a scholar right now, when we are working, we we are not objective. We cannot be objective. Law, as such, we all know is not objective also because it is made by some white men at that time, right? And that's how, and then we are trying to replicate that international law at different levels, and the ground realities are quite different. It is not made for it. So I think as a scholar who are working on that legal system or how do you see, and what could be some basic ways as a researcher to do so that we could also break that binary? Because I remember the moment we talk about victims, female victims, and the moment you talk about any other victims who is not a female, I was myself told, "Okay, listen, you are bringing competitive victimhood here. Don't bring it." So that is what also I think we are somewhere very much restricting ourselves. So how do we go about it? It's, I know it is little, we are little distracting from the main point, but I think how do we see going ahead in that way?
Should I answer this first?
I think you should, yes. Okay.
Thank you so much for the question. No, I think it's a very, very relevant question because we are constantly struggling with this when we are researching on such topics, right? When we are researching sexual violence, so these two categories of the aggrieved and the accused then become very, very relevant for us to look at how far. So there are two questions, right? One is that should we expand the category, because then there would be no end to expanding the categories as such, the kind of proliferation. But on the other hand, I think because this is also not a question that can be resolved anytime soon, I feel, because like you said, that this idea of category of the victim then also creates this overwhelming pressure on complainants to adhere to that particular category of victimhood. They have to show that we are this kind of a victim to get the law to work. And I think in case of international law, in particularly in case of refugee conventions, etc., you see this become very, very prominent, where a certain idea of, again, coloniality comes into being, right? Who is the ideal victim? The ideal victim would be the one which the global north can save from the clutches of the very repressive global south. And if you do not fit into that category of victimhood, you are not going to get rescued by the international conventions as such. If there is more complexity to your identity, you cannot really claim victimhood in this case at all. I think the only way that we can deal with it at this point is through constantly engaging and critiquing this kind of prevalence of such kind of judgments and such kind of resorting to the law. Other than that, right now, I think it feels really difficult to come up with any other solution other than constantly being at it that what's happening is wrong, to constantly challenge these kinds of perceptions, these kinds of judicial reasoning at all levels, domestic, international, at all levels.
Thank you. Thank you very much.
Thank you. Are there any other questions or concerns? Okay, I will then go ahead and say some of my bit. I'm constantly hearing us say, when I say us, I would include you and Sengupta and Sakshi and probably me as well, saying that, well, there's a certain way in which law kind of presupposes a structure for us to work with. And therefore, you know, the discomfort that Sakshi shared about the idea of the ambiguity of the category of the accused itself, right? So one thing is that law, in the way it is designed and the way it at least suggests that it's working, it has foreclosed possibilities of multiple interpretations, so to say, right? It seems to be very custard. And then we are saying at the same time that there are ways in which then contextualities are read, reinterpreted in the courtroom, so much so that in seemingly similar cases also, you will have different judgments coming out, which will probably be talking and saying things which are kind of diametrically opposite to each other. So what I'm hearing you say is that we have a problem of simultaneous ambiguity and simultaneous fixture, right? That's what I'm hearing us say. And I was wondering, is the problem there, right? And I would also then bring in the question of class, for example, and without getting into much great detail about the the sexual harassment and rape case, which was much talked about, where the feeble no in the consent and the loud no, right? And then the performance of, as you just pointed out, I mean, how much victimhood is victimhood enough? Like, did you shout no enough for us to know that you were really being victimized? So then comes the third, part of the triangle, which is performance, right? The judge performing themselves, the victims performing themselves, the perpetrators performing themselves. And within this also then the fact that law has to stand out. I mean, the idea of modesty comes from colonial baggage, but so does the idea of law. Right. So if we were to think across these three, ways in which, from what I've picked from everybody, including the discussant and the question, is that if we're talking about an objective criteria, which is important in a country as diverse as ours, as hierarchical as ours. So one is that some form of objectivity needs to be there. I mean, we cannot contextualize everything. And then we've seen how natural justice hasn't worked for us. I mean, I would like to assume that it could have worked for us, but hasn't. And therefore, you see every civil rights case moving directly up to the Supreme Court. I mean, if we had that kind of possibility, it would have worked within the natural rights framework. It didn't. So that need for objectivity, even at the cost of being a very black and white colonial thing, the need for objectivity, because you have so much of caste, class, region, religion, language playing, even with the hierarchical mode playing there. Then the need for context, because I'm sure the way a sexual harassment victim coming from an upper class accesses law, and the way that a sexual harassment victim coming from a lower class would access law. So then the need for contextualities, need for perhaps looking at the identity and the context and the location a little more. And then the third angle, which is the performativity, where I'm hearing both you, Sakshi, and Sengupta saying, well, a lot happens in the courtroom. Do you look, are you suited and painted and propped victim, or are you the bichari, the sulji hui, the seedhi victim? And then, of course, the whole gender conversation is entirely missing, because again, who can have modesty? So I was wondering, we are saying these three different things, and we're also saying all three are important. Right now, how do we solve this puzzle? I mean, it's a huge question that I'm probably throwing at all three of you. But how do we solve this question? Because law is important, historically so. And yeah, so that is me, because yeah, thank you for listening.
Thank you so much for these questions. Again, very important questions to think about. You are absolutely right. So I think there's a big role of justice being a performative act, right? Then justice just does not need to happen, but you need to show that justice is happening. And we can, I think more than ever now, it's very prominent, because you see all of these big cases being telecast through YouTube videos as public performance of justice comes into being. Everybody's performing their own role in that, and you have to adhere to a certain sense of victimhood in that sense. I was actually listening to a panel on how these cases actually play out in the court. So one of the big scholars on sexual violence and domestic violence, Leigh Gilmore, was actually talking about how even she, as a feminist advocate, actually uses a lot of these tropes to succeed in the courtroom. So she was like, I would do anything to get my client the whatever they want, right? Irrespective of whether or not it's a feminist way of arguing in the courtroom or not. So that's, I think, a very interesting way to think about how even feminism kind of becomes a part of this structure, because to get anything out of this structure, you need to negotiate constantly with patriarchy. Again, bargaining with patriarchy becomes an everyday act, everyday performance in courtrooms. There is no way out of that. And I think you're absolutely right to point out that these are the problems that we're grappling with, right? On one hand, there is, we feel that if context and subjectivity is not recognized, there will be no justice. On the other hand, the ambiguous ways in which context and subjectivity actually plays out in the courtroom actually is counterintuitive to the feminist ethics as such. Um, because whenever the courtroom actually alludes to, for instance, caste or class, it's never actually in the favor of the complainant as such. It's almost always used in a reverse way, no matter how it plays out. Again, a very good example is promise to marry cases, where on one hand, the cases are registered by parents of the woman when it's an intercaste relationship, consensual relationship, and it's against this man who is a low caste man. On the other hand, when the complainant herself is from a low caste and lodging a complaint that an upper caste man has uh, committed promise to marry, a false promise, given her false promise to marry. So here again, when the court uses or kind of pays attention to this question of caste, it's almost never to look at the subjectivity or the positionality or the embodied experience of the woman as such, whether or not she consents or does not. Her consent always becomes a judicial category which the judge interprets on their own. And the context is only read partially in those cases. So I think that is a big problem that we are particularly dealing with. And for some reason, uh, I know people do not like me saying this, but I think these are questions that mostly people coming from social sciences are very interested in, rather than people who are coming from a law background. Because for them, I think it's much easier to accept that law cannot give us everything. Like I was saying, that they will be much more satisfied in saying that, okay, law can do this, this, and this, and not more than that. But for us, it becomes a big question of law as a weapon for social change, and if it is actually something that inspires so much, if it is something that is so central to a democratic imagination of ourselves in India, then how do we deal with the conundrums of law? And I think it's good that all of us are thinking about these questions, because these need to be thought as we go along, and there seems to be no end to this kind of thinking about it. What was the last question? I think I got wound up in the first one.
I think I said everything together, which was the triangle of performance and I think objectivity.
Yeah.
I keep coming back to to law kind of there was and to elaborate more on it, there was a certain way in which political institutions, at least in the way social scientists have looked at it, were understood to be the instruments of the liberal democratic project, right? They were, and to borrow your own, phrase, that they're supposed to be instruments of social change. And there's a certain way in which we've set state apart from society. And when you were talking about how people have a certain faith in state and law, I was reminded of the enchantment with state, right? The Hamza Alvi kind of an argument that the state, literally held the entire society by its hand and pulled the society along with it, right? So in that sense of the term, I think there would be, I mean, it's my conjecture that there should be some merit in looking at objectivity or law working without its context, because then, as you rightly pointed out, in conditions where it's left fluid, it almost always, because of lack of social democracy, to borrow from Ambedkar's way of putting it, would almost always move in the direction of interpreting hierarchy and social in the favor of the powerful. So then how do we then reconcile this objective black and white, which seems to be problematic, but not so much if you look at the instruments, political institutions being instruments of liberal democracy, wherein that beautiful imagination of the the weighing lady who cannot see you, right? Lonely weigh the two, and then she'll come back to telling you, which by the way was, I think, it was removed from one of the quotes, if I'm not wrong. I mean, this was a news that I'd heard. So that is me digressing the point. But is there merit in asking and presenting that problem differently? Is there merit in looking at political institutions, especially the institutions of law, differently within that framework where the state and the society are still caught in a catching up game, and borrowing from your own phase of the social change that law and public institutions in almost in a wish fulfilling manner were given that responsibility of the constitution handing over the society to the state and saying, can you help move this along? So yeah.
Yeah, I think it's a very interesting question, because how do we then define objectivity itself? That also becomes a question for us. So if we look at standpoint theory, it tells us that whatever understanding of objectivity we have to first recognize that that objectivity is also partial understanding of whatever objectivity we develop. So I think the problem with law is that it does not recognize that the objectivity becomes the standard of objectivity for everything. So there is no understanding within law that everything is actually a partial and incomplete understanding. So that kind of the gap that then remains, that is never really recognized by the law. If something becomes a precedent, then it carries on being a precedent. And that then stops us from moving forward. Like we say that law is an instrument of social change, then if society changes, the law is also supposed to kind of change alongside that. But when objectivity becomes a gold standard for everything and a fixed standard for everything without recognizing that it's also a partial understanding of the situation, then I think we fix up all categories altogether, and then it's very difficult to move beyond those legal categories as such. And absolutely, the enchantment with the state, I think, somehow does not go away in case of India. Even though those articles are so old, but that those become so relevant even now. So when I went into the field to do my PhD research, I was actually thinking that, especially after the list of sexual harassers in academia came out, there would be a complete disenchantment with institutional processes. But actually what I found was that people still are working to make those institutions work rather than kind of completely going away from them. In fact, extra-legal resistances are used to make sure that the legal recourses work. So there is something inside this kind of deep enchantment with institutions and democratic institutions in India, and to save them, that I think all of us must kind of think very seriously about, because I feel like a lot of feminist recent times, a lot of discussion has been about how we must move beyond these institutions and law and all of that. But I feel like in reality, people still have that kind of a hope. And how do we then understand this kind of phenomenon? How do we then go forward with this kind of a hope in mind? I think we all are kind of stuck in this loop right now.
Okay, thank you so much. Thank you. This seems like a satisfactory answer at this moment, that we're all stuck and we have to move in the direction of finding some of these answers. So on that hopeful and note, if there are any other questions or concerns or comments, the floor is open. Otherwise, we'll close the session.
Yeah, just one question if I can ask.
Yeah, please.
So just wanted to ask whether you think the gender of judges also has an impact on the kind of judgment that are being passed. And secondly, when you are talking about legality and illegality and the aspect of justice, so there's also this theme of legitimacy and whether laws are really legitimate. So do courts also take on the charge of determining whether the relationships between the aggrieved and the perpetrator are legitimate, or whether, like, how do they view at it, and how do we look at the aspect of privacy there? So as you mentioned, the setups change when we talk about public and private lives. So how relationships in themselves are being viewed by the courts, that is the one of the questions. And then the gender of the judges, I wanted to know if that has an impact. And finally, if like we saw it in same-sex marriages, when courts kind of threw the question towards the parliament and kind of bypassed it. So can we really say that there is any ratio discendi sort of a thing happening in the courts, or they are just meandering, for the question, not, really taking on the charge of determining what should be, or making a very strict guideline or of that sort. So that one of my questions.
Yeah.
Thank you, Sakshi, for those questions. As far as the gender of the judges are concerned, I'm sure it might have an impact in most cases. But again, if you look at some of the judgments where you will see that sole dissenting female judge is giving the contradictory judgment to gender equality. So I think, was it Sabrimala? Yeah, I think Indu Malhotra gave a dissenting judgment in that case. So you can see how it's not just the gender of the judges, but I think a lot of other issues, also intersectional identities, also come into the fore as to how certain subjectivity of the judges can influence decision making at large. The other thing is also about legal education and how legal education in our countries have evolved. I think a very old piece by Veena Mazumdar actually talked about how legal education is a very, very important instrument in terms of translating judgments into gender justice gender just judgments. So I think those questions are again things that we can pick up on when we are thinking about how that impacts judgments. And about the legitimacy of the relationship, the accused and the aggrieved, I think that's a very important question. Also, particularly in case of workplaces and in case of universities as well, where you can see that even if there is a consensual relationship between two people who are very unequal in power, and then certain cases of sexual violence or sexual harassment happens, when that goes to the court, number one, it's very difficult for it to go to the court because of the stigma that is attached to premarital sex in India. And secondly, um, again, those same things that come up in promised to marry cases come up, that you consented because you were in love with this person. So there is also very interesting juridical reading of love that takes place through these judgments, that love becomes a way to nullify the lack of consent. Because you said yes at some point and were in love with this person, that means that you cannot actually say no at any point. It's almost assumed that it is almost like a marital relationship where there is no recognition of marital rape. There is also no recognition of sexual violence within long-term sexual relationships. The third question, I think I confused the third question again.
Yeah, it was on dodging the question to the parliament.
Yeah, I think again a very important thing that keeps on happening, that it's not within our power. So I think there the courts are actually taking a very straightforward thing of saying that we actually won't go against the logic of the state and make certain provisions or broader reading of these laws, even though actually they have done it previously, where they have actually gone beyond. Like if you look at the Vishakha judgment, it actually says that in absence of any regulation, in absence of any law on sexual harassment, we are actually pronouncing these guidelines and you have to abide by these guidelines. But the same logic becomes completely turned on its head when it comes to these recent judgments, whether it's marriage equality, whether it is the Binu Tamta petition as well, where you see that they're saying that yes, these changes can happen, but it's not within our hands. Go to the parliament and ask for changes there. So there is also this kind of shifting of responsibility. So the kind of faith that we have in law, then, that the law is trying to shift on to the parliament, where it kind of gives up the responsibility of being this force that can actually give people justice. Again, coming back to this question of legality, illegality is only concerned with the question of legality and illegality and deciding between deciding the line between that, rather than actually saying that we are going to take a position where there is some question of justice that comes up.
I also think it's a very social science problem, because a lot of judgments have realized, but this is not in our jurisdiction, and the matter ends. Like, I don't want to drag in another profession into it, but a lot of times when media persons are asked, "But aapke samne aag lagi hui thi," instead of really doing anything to, well, that fire, you decided to report on it. So I also think it's a very social science problem, because we are more concerned with separation of powers and jurisdiction and morality of law. And I think that is what Atreyee was trying to say, that sometimes those law isn't even asking those questions. It's saying, well, this is what the rule is, and I cannot say nothing about it. Of course, moral, well, that's not my problem. Go ask your legislature. So I think it's that, if I'm hearing you right, I think it's that kind of a issue. Very instructive, because we have that social science blinker, and in fact, a political science blinker at all things. Power kahan hai, power kahan hai, power kahan hai. So I think it's that kind of methodological problem that students of politics or students of law would find that they are in their own straight lane. Okay. On that note, unless somebody is holding a question in their pocket, which isn't. Atreyee, thank you so much for agreeing to do this. For me, it was very lucid, and I think there were a number of questions that you raised that we were perhaps not thinking about. And the discussion has also given us food for thought. Thank you for joining us today for the TheDaak Baithak. Thank you, Sakshi, for that wonderful introduction, and thank you, Sakshi, for that discussion. We will come back again next Saturday with another discussion on politics of memes and politics of social media. And we'd request and thank in the same breath all our participants to come back again if the topic interests them. And thank you so much for your participation today. And thank you to Atreyee.
Thank you so much for having me. I had a great time discussing social science, political science themes about law here, which I rarely get the chance to do. So thank you so much. It was really, really great to have all these questions and have this very, very enriching discussion.
Thank you, everyone. Good evening. Good night.